All right, good morning and welcome to the House Environment Committee. We are about to hear an amendment on S212.
I first thank you, Madam Chair. Thank you to the committee. Before I get into my amendment, I want to just make a quick statement. In my zeal, I'm sorry. Oh, Mike Taglavia, Orange 1, Corinth Orange, Berkshire, and I sit on the Environment Committee. In my zeal and enthusiasm to get this amendment, which I believe will actually make a good bill better, I seem to have jumped the gun on who to consult with. So I want to apologize to the chair, because I didn't realize some of the procedures that were in place. So please accept my apology. I also have apologized to my minority leader because I didn't realize I should have gone and explained to her my amendment as well. That being said, I do believe S12, which I did vote for, is a good bill. I think this makes the bill better because it helps to provide predictability and relief to people who apply for a permit, obtain a permit, and then find after the fact when construction is completed that they have a problem that turns into a very costly problem. And let me just quickly read the amendment in subsection 1974.
Walk through it with Ledge County.
Okay.
So we have to get on the floor, so I want to make sure we have time here.
Okay, there are instances in Hardwick and Sutton where this has come up. There was also an instance that I spoke with somebody in the southern part of the state less than 2 weeks ago who also ran into the problem. So this sounds like something that really does need a remedy, and that's the reason why I introduced the amendment.
Thank you.
Morning, this is Mike O'Grady. I am going to walk you through yes, 212 amendment, but to address Rep. Tagliavia's concern, which I have heard about before. I have heard this scenario happening before. It would have been cleaner or better to have put this in the wetlands chapter, but that might have created a germaneness issue. So I put it in the public water, the potable water supply and wastewater system chapter. And I think this does what Representative Taglavia wants, but it may also have unintended consequences. And so what this does, there is an exemption section in the potable water supply and wastewater system chapter. It's a list of activities that don't require a permit. For example, anything that was in the ground and operating before 2004 doesn't, or actually 2007 doesn't need a new permit unless it fails. This would add to that list of those activities that would not require a potable water supply or wastewater system permit if these conditions apply. So it's a system that was permitted, doesn't require a permit amendment or a wetlands authorization permit when, after the issuance of the potable water supply or wastewater system permit, the Secretary determines that the supply or system is located in a previously unmapped or undelineated Class 2 wetland. So you have been permitted by the agency to build your system. You have built your system, including potentially the structure served by that system. An A&R comes out and says, you're located in a wetland. Now, these scenarios are usually driven by complaints, and it's often neighbor complaints. And because DEC just generally doesn't go around looking for things, they respond to complaints. And you will see on page 1, line 14 to 16, that the exemption shall apply to the structure served by the potable water supply or wastewater system permitted under the chapter. And when these scenarios have played out, there have been significant fines that have been levied against those people that have built on reliance of their permit, their system or the structure served by the system. Now, what is the unintended consequence here? Remember, this program is largely driven by professional engineers or site designers, licensed site designers, certifying that a system meets the rules and requirements of the law. And the license of the engineer could be subject to challenge, suspension, even revocation if they're found by the Board of Engineers at OPR to have violated their professional standards. So professional engineers are very careful about complying with these requirements. This adds potentially an additional issue that they will have to review, because they will have to basically determine, they'll either have to say, hey, this is exempt, I don't have to look for a wetland anymore, because if it's unmapped or undelineated, I can just certify that the system meets the rules, technical rules requirements, and that will be fine because I'll be exempt. And that probably technically is true based on this language, but when you look at the OPR standards for professional engineers, they have to meet certain standards of analysis, evaluation, identification. So they'll probably err on the side of being careful and determine whether or not there is a wetland on the property. And that might slow this process down. Because if you have to go out and look for a delineation or to contract for a delineation, you may, as you've heard on the floor, wetlands delineations can take time because they're based on seasonality. It may slow the process down if you have a professional engineer, licensed site designer who is going to be careful about meeting their professional standards. So it's a little bit of you could have an engineer that's going to say, hey, this says I don't have to look just to see if it's unmapped or if it's undelineated. I'm just going to build. But then you're going to have engineers who are going to be careful and will likely look for delineations. And that may slow this process down. But this does what Representative Tagliavia wanted it to do. It would say that if you had your system, it was permitted, you started construction, you even finished construction, and then A&R comes and said, hey, despite your permit, you need another permit or you violated that other permit, this would say you would not need the permit amendment under potable water supply or wastewater, and it would say you would not need a wetlands authorization. But it has potential unintended consequences.
Representative Austin.
So does that mean septic would go into the groundwater?
So septic systems already potentially go into groundwater.
No, but untreated, I'm sorry.
No, I mean, the system is still permitted. The system is, you got your permitted potable water supply or wastewater system.
So the discharge would be treated? Right.
Yes, yes. I mean, right, it goes through whatever system you have, leach field, septic.
Can I ask? Wait. So can't engineers look at water tables? Can't you just look at water tables and see where water comes up historically in that site?
I mean, to get the permit wastewater potable water supply, you already have to do those things. This is about whether or not it's in a wetland, and wetland isn't just about the water table. The wetland is about, there are multiple values and functions that A&R looks at or professionals look at to delineate whether or not a wetland exists or not. So.
Okay, thank you.
So Michael, this would put engineers potentially in a kind of an awkward position. They have to sign off on this connection or the design. And then they may know that they're in violation of other permits. And then they would be potentially, I mean, that would be an OPR issue.
I tried to read up a little bit overnight on some of the OPR engineer cases. There's, for example, there was a case, an insurer went out to determine whether or not a home had been improperly constructed or properly renovated. And the insurer's engineer went out and looked at one thing, but didn't look at another, didn't ask for the information on another thing, didn't do a site evaluation. And the board said, you did what you were supposed to do. You looked at what you were supposed to look at, but you didn't do all of the professional standards that you needed to do in order to have an appropriate review and evaluation of this home. And I think you could see a similar issue here. The engineer puts in a system that meets the rules, but maybe the engineer knows that there's a wetland or thinks that there's a wetland there, and somebody files a complaint against the engineer, and the engineer says, well, I didn't have to look. And he said, well, no, you had professional standards to go. And so I can't say what OPR would do in a situation like that, but if you're an engineer, you're going to have to make that decision of how careful you are going to be.
Representative North, that's
Thank you, Madam Chair. I'm having a little trouble understanding, applying that logic to the addition of this amendment. Don't the engineers who install water or wastewater systems already have to do all of those analyses and already consider whether they might be putting a system in a place where it should or shouldn't? How does adding this after the fact exemption, which is really what it is, it's an after the fact exemption.
It is.
How does that affect? It doesn't. In fact, it doesn't affect that list of professional requirements that they need to meet. It's completely independent of that. So
No, but I think
the logic of how adding this would create a new set of conflicts.
I think your point is that they
They
already
have these conflicts.
they already have the standard. There's already, right, and they are supposed to be going out and looking, right? But now they have to make a decision of whether or not they're going to do that or not.
They already have to.
Right, but now they have this as kind of a blanket exemption. And does it relieve them of their professional standard? And I think you're going to have some engineers that are going to say, no.
So what you're saying, the link is that they might look at this as a backstop, as a safety net to not notice.
Right.
So.
Representative, yeah. Oh, sorry. Go ahead.
But in either case, whether this amendment is in or not, if they by accident didn't see something, they're still not meeting their professional.
They're still not meeting their standards, right?
Whether this is their. I was kind of struggling to understand how this amendment makes that any different.
I just think there's possibility there. I'm not an engineer. I'm just trying to inform you of what I think might be consequences of this.
And Taglivia, then Chapin.
Given the testing required to put in a septic, I don't know if it's called a perk test for the water to percolate or the effluent to percolate through the soil. Wouldn't a hydric soil be exposed at that point in the testing for approval or for an engineer to say this is the system will work?
I don't know, why perk test didn't identify wetlands in previous scenarios or not. And it's not just the perk or water that is used to identify a wetland. There's multiple other things like the vegetation, the aquatic biota. I mean, there's other things that are used to delineate where a wetland is.
Could it be as easy as another simple form so that on the date of filing of the system, or when the permit is actually issued, that there was no mapped wetland, class 2 wetland at the time when each of these systems was approved for installation?
Well, now you're getting into another consideration, and it's the consideration that's being reviewed by Elcar right now in the wetlands rules. The rules themselves actually say that the maps are unreliable. It says that the maps are kind of a beginning, and that in order to ensure that a wetland is present or not, that there needs to be a on the ground delineation. And there was testimony to Elcar, a couple of pretty respected wetlands professionals who showed how the map would show that a wetland was there, but it really wasn't, or a wetland wasn't present when it really was. And it creates not only an issue of reliability, it creates an issue of equity when you're talking about basing a decision on the map versus not on the map. That's why this says unmapped or undelineated, right? So it's not just that it's unmapped, it's undelineated.
I just go back to Representative North's point that they're doing a lot of this testing and review of the site prior to saying, doing the engineering and saying where actually on the property the best
So again,
place is.
I don't know why this happens, but it does happen.
Representative Chapin.
I guess I'd love to move to a different part of this, which is, I guess I thought, I certainly can imagine scenarios. We didn't really get time to hear some of the scenarios, but I can imagine some of them that result in this situation. And some of them where, people really did everything they thought they were supposed to do, and they end up, in a buffer, in a wetland, with a driveway or a part of a septic, whatever it is. So I certainly can imagine those scenarios. It's my understanding that the agency has discretion around fees and how to handle those situations. Can you talk about that? I don't want to make any assumptions, but
Fees are fines.
sorry, I mean fines
Okay.
and the whether to require the permit or permanent amendment or not.
So definitely they have what's called enforcement discretion. Every entity that enforces law has the ability, on a case-by-case basis, to look at the situation and the facts and to determine whether or not to bring an enforcement action against that alleged violator. It's just, the example that people give, so you get pulled over for speeding and the police officer just determines that he or she's not gonna give you a ticket.
Okay, so say I'm a neighbor and I think somebody just built their new septic system partly in a wetland or right up into the buffer or something like that. And I call ANR. So ANR has discretion about whether to take any action at all.
Yes.
They have discretion about whether to respond to the complaint, how to respond to the complaint.
Well,
Maybe not whether, but how.
generally, especially for certain types of violations, they're required to respond.
Okay.
To
at least look at it.
Right, and they generally do.
So sorry, so they have discretion. I just wanted to be a little bit clearer. So they have discretion about, they're likely to basically have to do something to look at the complaint.
They're gonna respond,
They're gonna respond,
evaluate, and then they have discretion to enforce or not.
to enforce or not, and then what level of fine to.
They do have some discretion there. There's precedent that they use in assessing their fines. But they do have discretion, and they can mitigate their fines as well.
Representative Austin.
Yeah, I'm just wondering with this amendment, if a contractor built a house and it happened to be in a wetland, would that be grounds for a lawsuit either from a neighborhood organization or from neighbors or the homeowner to sue the contractor? If they had a wet basement or a flooded basement?
You know, those kind of civil actions are all fact dependent. But there's possibility there. There's possibility that A&R brings an enforcement action against you. There was an incident where they required the house to be removed.
A&R.
Yeah, and it was an egregious. It's not this type of thing where someone's acting in good faith. It was someone was acting not in good faith.
But with this amendment, we wouldn't be sure if they were acting in good faith.
Yeah.
Well, they've got a permit, right? They went out, they obtained their permit, they did what they were required to do,
Yep.
Build the structure. Does it relieve potentially some people looking for a wetland? Maybe.
Leave them looking for, oh, yeah, they wouldn't look, right. Yeah.
Kristen.
Yes, I see Christy Moore. Christy, go ahead.
Thank you,
You're
Madam
mute.
Chair. I'm just trying to understand the consequences of this a little bit in my mind. On line 15, it says that the exemption shall also apply to the structure, which is singular. In my mind, it's singular. So are we talking about a wastewater system or a water system that's serving a singular house? And what might some of those amendments be in that situation? As opposed to a system that's serving, say, multiple houses in an area, which by saying structure and being singular, I'm assuming it's not plural.
So in Title I of the Green Books, there's a whole chapter on how to interpret statute, and one of those sections says the singular can be interpreted as the plural, and the plural can be interpreted as the singular. So it is both singular and plural. It could apply to a system that serves more than one structure. I do want to note that the definition of structure under the A&R potable water supply and wastewater rules is broad, very broad. It includes everything you could potentially think of unless it's specifically exempt from the definition of structure. So it's not just residential houses, it's hospitals, schools, commercial, restaurant. And they do list, I'm just trying to recall the list of examples that they provide.
Okay, thank you, I guess.
Oh, Neil, did the agency want to speak on this?
I'd be happy to if you'd like me to. Good morning, committee. For the record, Neil Cameron, Deputy Commissioner, DEC. Thank you. I want to say very briefly first, I really like S212, and I very much encourage you to move it across the floor because there's a lot of good policy in there. So thank you for your work on it. I think the department needs to understand more before we can support an amendment like this. These instances that do happen, but they're also really fact specific, and I just don't know enough about the details to see that this should be legislated at this time. I think my initial reaction on behalf of the department, and I've consulted with Director Redmond on this too, is that we have concerns over how this may potentially be misused in a manner that others on this committee have been talking about. I believe all of our designers and all of our engineers out there approach their job with the best of intent, and to produce for their clients the things that their clients want to build, and to guide their clients when they can or can't build in a certain area.
And I also am aware that sometimes those good professionals, receive pressure or are delivering bad news to the landowners, right? May not be able to do that there, and that may be exactly where the landowner wants to site their house or whatever. I'm just a little worried about the unintended consequences in this amendment, but it would need to understand sort of some of those specifics, and we may already be aware of some of those specifics and may have already kind of gone through the enforcement process on them. I don't know what the instances are that this amendment is looking to fix. So, but I would be at the very minimum, something in statute that's retroactive versus something in statute that just opens the door into the future to any erroneous assessment, probably would be a little bit better. My point being, as I read the language, that it's just sort of open-ended, broad, time, not time constrained. So if the legislative intent is to fix something for a set of somebodies, that gets fixed, but that it doesn't sort of create the opportunity in the future for inaccurate assessment of land for the purpose of siting a wastewater system.
Thank you. Do members have questions? Representative Tagliavia.
With respect to a couple of that, and I don't know all of the details, but one of the subjects that was brought up was enforcement and discretion. One fine was reduced for a young family from $60,000 to $30,000.
I know which,
If
I
you
know the site.
Barely afford the mortgage and everything else. That discretion still doesn't make it affordable after the fact. I'm talking, and the genesis for this was people who are acting in good faith, including the engineers. I'm not talking about somebody who gets cajoled, bribed, whatever. I'm talking about people who, in good faith, hire someone to draw up a plan, deal with what they believe is all of the permits, and then find out because somebody doesn't like where a garage is placed or something to that sort, or somebody builds a house on a piece of land that's been vacant for 60 years and now all of a sudden the neighbor doesn't want to look at it. These are the type of instances where I'm talking about, one in southern Vermont that wound up in tens of thousands of fines because someone didn't like to look at a garage. And it was permitted and it was there. And then an after the fact visit. These are the types of things that myself and the co-sponsors are trying to stop.
I understand that. And if I could speak to the first instance that you cited, and we'll obviously won't cite names, but I'm extremely well read into that situation. Others in the building have talked to us about it as well. And that's a difficult one. But it's also not what this amendment is intending. So this amendment is intending to modify the placement of wastewater systems, right? And at issue in that other piece that you're talking about is fundamentally violations of the Vermont wetland rules. And they're separate here. I believe this, if I'm not mistaken, this amendment speaks to the potable water supply rules and would exempt a system that was inadvertently placed in a wetland from, having to go back for amendment. That is different than somebody having done a land development project and advertently or inadvertently having impacted wetlands in contravention to the wetland rules. It's a different situation, I think. That's a very difficult situation, Representative. I'm well read into it. I think I know the Southern Vermont one you're talking about as well.
Other members have questions for Mr. Cannon?
Oh,
Or not, or someone.
yeah. When the wetlands mapping is completed, will it be very precise so people will be able to make better decisions, have more information to make better decisions on where and where not to build?
I feel like we're talking about the Vermont wetland rules as opposed to the bill at hand, but I'll answer the question, Representative, of course.
Trying to think ahead. If
There's
we postpone, will these situations be avoided?
there there are differing perspectives on the dispositiveness of the mapping, right? So the administration's position through the Vermont Wetland Rules Amendment is that within those geographic zones, we're creating that allowed use to allow development to occur in non-map wetlands. Going forward, wetland maps are always getting better and better, right? So if somebody gets a delineation and they go forward and they get a permit, after they're permitted, that delineation gets added to the map. So that's like very precise, right? For a 10-year period of time. The maps are intended to be updated every 5 years. So they're getting better and better. Frankly, the administration and my department would love to get to a place where those maps create the kind of regulatory transparency that Vermont owners need because of the situation that Representative Tagliavia brought up, right? And ones like it.
Other questions on the amendment? All right, not seeing any. Thanks for joining us.
Thank you very much. You have a good day. I'll be around for a little minute.
Other thoughts on this amendment? Representative Stackwoods.
Yeah, I think the problem that the representative is trying to solve here, that the representatives who introduced this amendment are trying to solve is worth a very close look. And maybe there's parts of this which are really worthwhile and which could really work. But this is from the questions that and the testimony that we've heard this morning, it seems like we're really not sure exactly what the effect of this will be. Like some of the other amendments that have come before us, it really seems like, you know, this just needs more work, that we would need more testimony. We need to find out more about what these unintended consequences that Ledge Council has brought forward, what they really mean before we put this in statute.
Representative Lipsky.
Thank you, Madam Chairman. I'd like, as a co-sponsor, be able to speak if I may.
Just called on you.
I'll try. Keeping things brief isn't easy for me, but a few clarifications. A lot of terminology's been bantered around, and many of the questions they're based on that. They're not ignorant questions, but there's a lack of knowledge of, for instance, perk tests generally for subsurface sewer systems are not done. What's done now in Vermont by statute and is highly regulated are deep observation pits. And those need to be typically they're 7 or 8 feet, and there's you need to be a licensed engineer, sanitary engineer, to analyze the soils. And it starts, sort of to your point, modeling, not modeling, but modeling is a characteristics in soils that indicate at some time that might have been a high groundwater elevation at some point in history. So that analysis, and it's both texturally as well as by color, there's a very complex color code. And those are indicators of the soil's ability to properly support a subsurface sewage system. And that analysis drives the design of that system. And the design impacts the cost. Some can be in ground, although in Vermont, typically only about 80 or so percent of, only about 20 or less, 18% of recent subsurface sewage systems are in ground because the soils are excellent. If they're not, you have to go to more expensive system at Presby or a mound system. But then that's one thing with regard to perk tests. And these engineers have their livelihood and their education and their license and seal on the line. And I've been involved with many projects like this. And always a site plan is part of the presentation. It's just not an obscure design. It actually shows the location of the septic tank, the leach field, and adjacent wetlands, whether it's a noted wetland or an intermittent stream or a perennial stream or a pond, whatever. But a lot of what we're talking about is not building in a wetland, it's building in a too close to the buffer. You could have a wetland there that's clear and delineated. You have to have a distance away. So it's really a buffer to the wetland. There's a big distinction. It seems beyond irreverent to build in a wetland. It's impossible.
Excuse me, the amendment is actually talking about wetlands. And I can't, I'm
Yeah, but-
asking if you
but-
could keep your comments to the amendment. That'd be helpful.
The amendment is about being able to install a wastewater system. No one's asking for an exemption to build in a wetland. It's,
Really?
the violation seems to be in a buffer. And then the real basis has to do with, and motivation why I supported this is the impact on moderate income or lower income honors that are trying to build a home and follow the rules. It seems impressive to hire a professional engineer, do all the work and the siting and the construction, and then be cited and fined. And I also am going to stand up. I'm not licensed. I've been a health inspector for rural communities for wastewater, but I have never interacted with someone that was corrupt or not honorable. Their licenses are critical to their survival. So I think corruption, dishonesty exists. I don't think anyone would put a client at risk by violating. Thank you, Madam Speaker.
Do you need to go to the floor and be with the speaker? All right, further comments on this amendment? All right, we'll do a straw poll on it. All those who are in favor of the amendment, raise your hand. 3 in favor. All those opposed to the amendment, raise your hand. 6, Rep. Logan, are you with us?
Sorry, I was struggling to unmute. I am opposed.
All right, all right. So 7-3 unfair. And 3-1. Thank you all. We will adjourn for the day, I hope.